Well, this case has its roots in the redistricting that goes on in state legislatures across the country every 10 years based on the census results. And so last year, the 2020 census results, which came out late because of the coronavirus pandemic, were used by Alabama and every other state that has more than one congressional district to produce a new congressional map based on population changes. So Alabama's lawmakers drew a map last year. They have 7 districts. In 6 of the districts, white voters make up substantial majorities, and in 1 district, Black voters make up a majority. And that's the way it has been in Alabama for roughly the last 30 years. This time, Black voters, represented by voting rights groups, went to federal court to sue to say that actually, based on Alabama's population, which is more than 1/4 Black, the state should have 2 congressional districts in which Black voters really had a chance to elect their candidate of choice. The case was initially heard by a 3-judge court, which hears cases about voting rights. And the court was made up of 1 appointee who had been put on a federal appeals court by former President Bill Clinton, a Democrat, and 2 appointees of former President Donald Trump, a Republican. And that court concluded unanimously that the challengers were right, that Alabama should have drawn a 2nd district with a Black majority or close to it under the Voting Rights Act. The state, instead of going along with that, went to the Supreme Court and appealed. They filed an emergency application to get the court to weigh in before any of these deadlines for either drawing a new map or qualifying started. And so what happened on Monday is that the Supreme Court blocked the lower court ruling. In other words, it reinstated the map that Alabama initially drew, the one that only has 1 Black majority district, and basically said that's the map that will be used for the 2022 election. And so in this case, Justice Brett Kavanaugh, joined by Justice Samuel Alito, wrote that this court order by the lower court came too close to the start of Alabama's qualifying period. Now, the court has, for about the last 15 years, really objected when courts order changes to election-related laws too close to an election. So the court has grown more conservative since 2013 and has had 2 decisions which essentially weakened the Voting Rights Act. Voting rights advocates fear that this case could produce a 3rd decision, which would really affect minority political representation, not just in Alabama, but potentially across the country.